Okay, let's unpack this. Imagine walking into court with a discrimination claim about your job, only to find out there's this extra hurdle.
Yeah.
The law puts in your path just because of who you are,
Mm-hmm.
specifically because you're not part of a group that's, historically faced discrimination. Sounds kind of backwards, right?
It really does. And, well, until just very recently, that was the situation for people in certain parts of the U.S.
But the Supreme Court just weighed in. Big decision.
Yep, unanimous. And it basically tore down that extra barrier.
So today we're doing a deep dive into Ames v. Ohio Youth Services. It might sound a bit technical, maybe.
A little bit, yeah.
But it has really significant consequences for how discrimination gets proved, how it gets challenged in workplaces, well, everywhere.
And our goal today, looking at all these sources you've built together, we've got legal analysis, court docs, HR stuff, even like online discussions, is to cut through the jargon. We want to boil it down to the essential so you walk away really understanding what this ruling means, whether you're an employee or running a business.
Absolutely.
Yeah.
And to get why this even reached the Supreme Court, we need to start with the person involved, Marlon Ames.
Right, Marlon Ames. So she's a heterosexual woman. Worked for the Ohio Department of Youth Services for, I think, over 15 years.
Yeah, long time.
And her claim basically was that she was denied a promotion and then later got demoted. And she alleged these roles ended up going to LGBTQ plus individuals.
Okay.
So she filed a claim arguing it was discrimination based on her sexual orientation.
Okay, so alleging discrimination. Now, usually federal law protects against sex discrimination, and that includes sexual orientation now.
Right, after Bostock.
Exactly. But here's where that extra legal barrier you mentioned kicks in, right?
Yeah.
Because she's heterosexual, which some courts saw as a majority group.
Precisely. In, I think it was 5 federal circuits.
Yeah.
Plus D.C.
Yeah, something like that.
Including the 6th Circuit, where her case was. These courts had developed this rule, this extra requirement for plaintiffs from what they called majority groups, like white individuals or heterosexual individuals like Miss Ames.
They needed something more just to get their case going.
Yeah, exactly. A higher standard.
And what was that higher standard? What do they call it? What extra thing did plaintiffs have to prove?
It was generally called showing background circumstances.
Background circumstances.
And it meant someone like Mrs. Ames from a majority group couldn't just show the usual things you need for a discrimination claim.
Like what?
Like, being qualified, suffering a negative action, someone else getting the job.
The standard stuff.
Right. She also had to somehow prove there was something, unusual, something odd about that specific employer suggesting they were inclined to discriminate against majority group members.
Wow.
It was an extra burden, totally based on their group status.
So instead of just proving she was treated unfairly in that specific instance, she had to show the whole company had this weird bias against straight people generally. That sounds incredibly hard to prove.
Well, many sources certainly saw it that way. It definitely added a layer of proof complexity that just wasn't asked of minority group plaintiffs bringing the same kind of case.
Right.
And that became the big question for the Supreme Court. But maybe before we get to the ruling, we should quickly touch on Title VII itself and how these cases usually work.
Good idea. Title VII of the Civil Rights Act 1964, the big one for workplace discrimination.
Exactly. Bans discrimination based on race, color, religion, national origin, and sex. And yeah, like we said, Bostock in 2020 confirmed sex includes sexual orientation and gender identity.
Got it. So if you're bringing a Title VII claim and you don't have, like, a smoking gun email.
Right, direct evidence, which is rare.
The courts use a framework, right? To sort of figure it out based on the circumstances.
Yeah, that's the McDonnell-Douglas framework. It's been around for ages. It's basically a structure, a few steps, to let a plaintiff build a case using circumstantial evidence to create an inference of discrimination. Usually, the first step is showing what's called a prima facie case.
Prima facie, meaning like on its face, enough initial evidence.
Exactly. Enough to suggest discrimination might have occurred.
And what does that usually involve? What are the steps for that initial showing?
Well, the sources lay out the typical elements. 1, you're in a protected class, race, sex, etc.
Okay.
2, you suffered an adverse employment action, fired, not promoted, something negative.
Right.
3, you were actually qualified for the job or promotion.
Makes sense.
And 4, someone outside your protected class who was similarly qualified got treated better. Like, they got the job, you didn't.
Okay, so that's the standard 4-part test.
Yeah.
And this background circumstances rule that hit Marlon Ames, that just tacked on a fifth step, but only for majority plaintiffs.
That's exactly right. It piled that extra requirement on top of McDonnell-Douglas purely based on the plaintiff's group identity. And this is where, some sources and legal briefs brought up the term reverse discrimination.
No, I saw that too.
Yeah, it can be a loaded term, kind of controversial. But the core legal issue for the Supreme Court was really simpler. Should the standard for any Title VII discrimination claim change depending on the plaintiff's group?
Because Title VII itself just says...
It protects any individual. That's the phrase the court keyed in on.
Which leads us right to the main event. The Supreme Court's decision in Ames. What did they rule?
Unanimous. 9-0. They completely struck down the background circumstances requirement. Gone.
Wow, unanimous. That doesn't happen every day with this court.
Yeah.
What was the reasoning? How did they all agree?
Justice Jackson wrote the opinion for the whole court, and the reasoning was really direct, focused on the text. She stressed that Title VII protects every individual, that's the language, from discrimination based on race, sex, all the listed categories. The statute, she wrote, just doesn't leave any room for courts to invent different, tougher standards for plaintiffs based on whether they belong to a majority or minority group.
So the law says any individual, and the court is saying, yeah, we actually mean any individual, full stop.
Pretty much, yeah. The court said this background circumstances rule just didn't fit with the actual words Congress wrote. And it also clashed with earlier Supreme Court cases that told lower courts, basically, don't make these discrimination-proof rules too rigid or complicated. They felt courts shouldn't be adding extra hurdles that aren't in the law itself.
Okay, so they got rid of the rule, but did they decide if Marlon Ames herself faced discrimination? Did she, win her case then and there?
No, and they were very clear about that. The Supreme Court did not rule on the merits of her specific claim.
Oh, okay.
They just removed that extra background circumstances barrier she shouldn't have faced. So her case goes back down to the lower courts.
To be looked at again.
Exactly. To be reevaluated using the same standard that now applies to absolutely everyone, no matter their group identity.
Okay, so the playing field for starting a case is now level everywhere. What are the big takeaways, the implications of this? What changes now for employers, for employees?
Well, the biggest immediate impact, which pretty much all the sources highlight, is it lowers the initial bar for majority group plaintiffs.
Makes it easier to bring a case.
Especially in those circuits, those 20-plus states in D.C. where the old rule used to apply, that extra hoop is gone.
So does that mean we should expect, a wave of new lawsuits from majority plaintiffs?
That's definitely the prediction you see everywhere in the legal commentary. Experts widely expect an uptick in discrimination lawsuits filed by members of majority groups, particularly in those areas that use the old rule.
Okay. Now, you mentioned the McDonnell-Douglas framework earlier, the standard way these cases are usually analyzed. Did the Ames ruling change that framework?
No. Ames explicitly did not overturn McDonnell-Douglas. That basic structure for looking at circumstantial evidence still in place.
Okay.
However, and this is where things get really interesting and where some sources see maybe storm clouds gathering.
Uh-oh. Here comes the but.
Exactly. Justices Thomas and Gorsuch, they wrote a separate opinion. It's called a concurrence.
Meaning they agreed with the result, getting rid of background circumstances.
Right. They fully agreed on that. But they used their separate opinion to launch a pretty direct criticism at the McDonnell-Douglas framework itself.
Criticize the whole framework. Why? What's their issue with it?
Well, reading their concurrence, they basically call McDonnell-Douglas an atextual judicial creation.
Atextual, meaning not in the text of the law.
Exactly. Their argument is that this whole complex multi-step thing, Congress didn't write it into Title VII. Judges made it up over the years. And they seem pretty skeptical about whether it's the right way or even a good way to figure out discrimination when there's no direct proof.
And did they hint they might want to revisit McDonnell-Douglas down the road? Maybe get rid of it too.
They strongly signal that, yeah. They specifically mentioned a case from earlier this year, Hiddle v. City of Stockton. They had dissented when the court decided not to hear that case.
Okay.
And in that dissent, they'd already raised doubts about whether McDonnell-Douglas was really a workable and useful evidentiary tool. Their concurrence in Ames basically says, yeah, we still think that.
Wow. Okay, so the main Ames ruling makes the standard apply equally to everyone. But this concurrence from two justices is questioning the standard itself. That feels like a pretty big deal for where discrimination law might go next.
It's absolutely being read that way by legal watchers and the sources, yeah. It suggests that while Ames brought uniformity for now, there are justices ready to potentially re-examine the entire foundation of how these cases are proven.
And some sources are connecting the dots, right? Between this ruling, the concurrence, and other recent Supreme Court decisions affecting employment or related areas.
Definitely. You see links drawn to cases like Students for Fair Admissions.
The college affirmative action case.
Right. And also Muldrow, the case about discriminatory job transfers not needing to cause significant harm. The thinking in some commentary is that when you look at Ames, plus the Thomas Gorsuch concurrence alongside SFFA and Muldrow, you see maybe a broader pattern emerging from the court.
And specifically, some commentary connects Ames and that concurrence to the whole debate around diversity, equity, and inclusion DEI programs in workplaces. How does that connection get made?
Well, sources point to things like the legal brief filed by America First Legal in the Ames case itself.
Okay.
And they note Justice Thomas, in his Ames concurrence, mentioned what he called an obsession with DEI by some businesses. The argument being made, as reported by these sources, connects the core principle of Ames that Title VII protects every individual equally to legal challenges against certain DEI practices.
How so?
The logic, according to these sources, is if the law demands equal treatment and the same standard for everyone, regardless of race or sex or other group identity, then maybe practices perceived as giving preference to or discriminating against any group could be vulnerable under this reinforced principle of equal treatment.
So the argument is that Ames, by demanding the same standard for bringing a discrimination claim for everyone, plus the concurrence questioning the proof framework, might give ammo to challenge DEI efforts that are seen as not treating everyone equally.
That's precisely the connection being drawn by some legal groups and commentators, yeah. They see the court emphasizing that the law must be applied the same way to every single person as potentially boosting legal arguments against practices they view as differentiating based on group identity.
It's important to stress, though, Ames itself wasn't about DEI, right?
Yeah. Absolutely crucial point. The Ames decision did not rule on DEI programs directly, but the principle, it strongly reaffirmed equal application of the law to individuals, and the questions raised in the concurrence about proof standards are definitely being viewed through that DEI lens by some.
Okay, that makes sense, seeing how the arguments fit together.
Yeah.
So in this environment-level playing field for claims, maybe more lawsuits, potential questions about the proof standard itself, and the scrutiny on DEI, what's the practical advice coming out of the sources for employers? What should they be doing now?
The advice is pretty consistent across the board, focusing on, well, consistency and documentation.
Okay.
Legal experts are saying, first, really scrutinize all your employment policies. Hiring, promotion, reviews, discipline, termination, everything. Make sure they're applied the exact same way to every employee, regardless of group.
No exceptions based on who they are.
Right. Second, use clear, transparent, job-related standards for qualifications. Make it obvious why someone gets promoted or hired based on merit. Third, strongly consider getting legal review before making big employment decisions. Promotions, demotions, firing, even major transfers, especially if there's any whiff of risk.
Better safe than sorry.
Exactly. Fourth, documentation is key. Document performance issues objectively. Document disciplinary steps. Document the specific, non-discriminatory reasons for every major decision. If you can't show why you did something, it looks worse.
Makes sense. Anything else?
Yeah, training. Train HR, train managers. Focus on unbiased decision-making for all employees. Reinforce that equal treatment principle.
Okay.
And finally, related to that DEI discussion, the strong advice is review those initiatives with legal counsel. Make sure they align with this principle of equal opportunity for all individuals and are legally defensible, especially in light of Ames and the broader legal trends.
So the bottom line for employers really seems to be consistency is king. Treat everyone the same, use objective criteria, write everything down, get legal advice on big moves, and be mindful of how all practices, including DEI, fit with this reinforced equal treatment standard.
That sums it up perfectly. The standard for bringing a claim is now uniform, maybe easier for some, which raises litigation risks. But the fundamental principle the court hammered home is equal treatment under Title VII for every single individual.
So there you have it. The Supreme Court, unanimously in Ames v. Ohio Youth Services, has said Title VII means what it says. It protects every individual equally. That extra higher standard for majority plaintiffs that existed in some places, it's gone.
Which means a single uniform standard across the whole country now. And as we discussed, the sources widely expect this will likely lead to more litigation of certain types and definitely ongoing legal scrutiny of workplace practices through this lens of equal treatment for all.
This unanimous Ames decision really underlines that basic idea. The law shouldn't see race or sex or orientation when it comes to workplace discrimination claims. It should see the individual. As you think about all this, maybe consider how this powerful reinforcement of equal treatment might impact the whole conversation we're having about fairness and equity at work. What does genuine equal opportunity for all really look like in practice going forward?